I'll give you an opening statement in a pedestrian knockdown case, and I want to show you and share some problems with you that we have in these cases. Every once in a while you get a case into your office and you take a look at the police report and you're afraid to share it with your partners because you know if you do they're going to say, get rid of this case, we don't want it. Well, here's an actual case that we had. Came into the office, and this is the police report. I have it right in front of me, and this is what it reads. Operator of vehicle number 1, right-hand turn, when pedestrian ran into vehicle number 1. This is going to sound familiar. Pedestrian also stated, it's not your fault, I ran into you. This is the opening statement. So what happens is we get this case. Now, what do you have to do when you get a case like this? Well, you got to go through the facts first, because in my office I have to bring it to Bob, and Bob's going to say, wait a second, let's talk about this case a little bit. And he's right. We want to talk about this case. But what do you really want to do in a case like this? If it's an injury, you want to evaluate the injuries. You saw Evan go into the injuries in his opening statement. Well, you have to do that. And if you think about this, very often, if we have a case like this case happened to have taken place in Manhattan, but we were able to bring the case in Brooklyn. We brought the case in Brooklyn because at the time we felt the jurors were better for us in Brooklyn. Since we had the choice, why not do that? But there's a problem in bringing a case in Brooklyn. And the problem is, if you bring the case in Brooklyn, you're absolutely right. Say it. What's the problem? Bifurcation. Right. Bifurcation. What are we going to do with this? Well, if it's bifurcated, maybe you're going to get hurt. But if there's something we can do to unify the trial, perhaps that's a better way of doing it. Perhaps it's a way of making your point that much more clear. So let me give you a case. Write this case down. I don't give you too many sites, but the ones I do are important. This is a case by the name of Karen Lind versus the City of New York. It's a case that Bob Coniston happened to try. 270 Appellate Division 2nd, 315. That's 270 Appellate Division 2nd, 315. 705 New York Sub 2nd, 59. 705 New York Sub 2nd, 59. It's a Second Department case.
Tell us the year.
Gosh, if I could read it. 2000. It says this: a unified trial and liability of damages is appropriate where the injuries have an important bearing on the liability itself. So if the injuries have an important bearing on liability, you can make the motion. You make the motion, hopefully, so that you get the unified trial granted, and guess what? You can often get a much better result by doing that. It means a little bit more work on your part because you have to evaluate the medicals. Well, as luck would turn out, there were always 3 guys in Brooklyn that I saw all the time when I used to try cases there regularly. I don't try them regularly anymore in Brooklyn. But I will tell you, the lawyers were Stu Bailey, there was Normie Heller, and there was another guy named Walter Beck, for those of you who remember. This one happened to be against Walter Beck. Walter's a fine lawyer. And I will tell you, he opposed the motion. We won the motion. We were able to show that, in fact, the injuries did have an important bearing on liability. So let me give you the opening statement. You'll see the way that I dealt with this for the jurors to see what happened. Ladies and gentlemen, on June 12th, 2003, a woman was injured. She was injured severely, and she was injured because a driver failed to keep a reasonable and proper lookout, and because that same driver failed to use that degree of care that he should have when he was making a right-hand turn at an intersection. In fact, as a result of the failures on the part of that driver, as a result of the carelessness, as a result of the negligence on the part of that driver, this woman has been injured, and she has been injured severely, so much so that the injuries will be with her for the rest of her life. The woman that was injured is my client, Doris Dana, who happens to be right over here in the back of the courtroom. So let me take you back in time to tell you who she is, so that I can introduce you to her and so you'll know exactly what happened to her. Doris is a woman who grew up in Manhattan. She's lived here her whole life. She's worked here. In fact, on the day of this accident, she was working. She was working in downtown Manhattan. At the end of the day, she took the subway back up to 50th Street and 8th Avenue, and her intent was to walk the rest of the way home, and that's exactly what she did. So she got off at 8th Avenue and she started to walk right up 50th Street on the south side of the street, and it was her intent to cross at 10th Avenue, to cross right at the crosswalk, and that's exactly what she was going to do. What she didn't know at that time, and what she couldn't have known, is that there was a driver heading northbound on 50th Street, and what she couldn't have known is that driver would turn right into her without ever looking, without ever stopping, without ever checking to see if there was a pedestrian in the crosswalk, but that's exactly what happened. So here's what happens. Doris Dano gets to the intersection of 50th and 10th, and she's going to cross the street going north. And as she's going to cross the street, she looks across the street and she sees that the walk, don't walk sign is not in her favor. So she waits, and she waits for it to turn. And when it turns, it's then that she starts to walk right in the crosswalk, and sure enough, as she's walking in the crosswalk, the driver is coming from behind her in the exact same direction. As she has the walk sign in her favor, the driver has the green light in his favor. What she didn't know, and what she couldn't have known, is that he's going to make a right-hand turn right into her. And in fact, this is exactly what happens. As she crosses into the crosswalk, when she's halfway through the crosswalk, the driver makes a right-hand turn into her, and he strikes her, and she falls right to the ground, and she is injured. Let me tell you this, though. The driver of that car speaks to the police. Doris Dano does not have an opportunity to speak with the police. She's taken away in an ambulance before she ever has the opportunity to speak to the police. So the only information that the police had as to how that accident happened was given by one source, by one person, and that one person was the defendant driver. And the defendant driver said something at that time that we dispute. What he said was, Doris Dano was running, that she wasn't looking where she was going, and that she ran into his car when he was making the turn. And then he said something else. He told the police officer that she stated, "Don't worry, it's not your fault, I ran into you." Ladies and gentlemen, we will prove to you, make no mistake about it, that that is not true. Not based on words, not based on he said and she said, but based on the medical proof in this case, because it is the medical proof in this case that explains the way that this accident truly unfolded, not through what one person said or what another person said. And here's what I mean. Doris Dano was struck by that car, but she was struck by the car in a specific area. Unlike what the defendant driver is saying, that she ran into the car, if she had run into the side of a car, there would be injuries. There would be injuries to certain parts of her body, specifically her knee, which was injured. There would be injuries to the area where I'm pointing right now, to the quadriceps tendon, to the kneecap, to the patella tendon. But in fact, the hospital record reflects one thing, that there is no injury, none whatsoever, to the front of her leg. In fact, the injury occurred to the side of her leg. To the area where I'm pointing right now, to the lateral side of her leg, this area right here, this is the area that was injured. And in fact, she suffered a specific injury known as a left lateral tibial plateau fracture. And to explain this, I have to go into a little bit more of the medicals. The proof in this case will show that the largest joint in the human body is the knee joint. It's where the two largest bones in the body meet. The femur, the bone running from the hip down to the knee, meets up with the tibia running from the ankle up to the knee, and they form this joint, which is a hinge joint, and it only moves up and back. It doesn't allow for the range of motion like my shoulder, like what I'm doing right now, up and back and all the way around. But the bones themselves actually meet at an area where the tibia, they call it the tibial plateau, the top of this bone right here that I'm pointing to, the top of the bottom bone, meets the femoral condyle, the femur, right at the knee joint. And if you've ever taken a look at a turkey bone or a chicken bone, you know that at the very ends of these bones is a smooth, white, glistening surface. Well, that's known as articular surface, and that allows for that free flow and even movement of the bones to allow us to move without pain or without any arthritis, without any trauma. But in fact, when the defendant driver drove into Doris Dano, he caused an injury to the left lateral tibial plateau, fracturing the bones only on the side of her knee, only caused by a bumper hitting her this way. This is the direction that the car was coming. So make no mistake about it. It's not what he said or what she said. It's the medical proof that answers the case as to how the accident unfolded. Doris Dano was taken into surgery, and the doctors did do a major surgery trying to reconstruct her tibial plateau, which actually suffered a depression of 1.5 inches, and they had to use bone from this area of her body known as the iliac crest. Some people refer to it as the hip. It wasn't enough bone. They actually had to take bone from a cadaver, bone from a dead body, to help rebuild that knee. But the problem for Doris Dano is, although she was hospitalized for more than a week, and although she has had weeks and months of physical therapy, the bone itself had never healed properly. The articular surface was destroyed in that accident, and because of that, bone was rubbing against bone. So as time goes by, the knee becomes more and more arthritic, and that's all arthritis is. It's when the articular surface is destroyed and bone rubs against bone. For Doris Dano, though, the doctors have given her a prognosis, which is an unfavorable one. And they have told her, in no uncertain terms, that she needs something known as a total knee replacement. And the one thing the doctors have also told her is that there is no guarantee, none whatsoever, that they'll give her medically, that it will work. But for her, she has no choice. The problem, though, with this procedure is not just that there are no guarantees, and not just that she'll have the pain from the surgery, and not just that she'll have additional physical therapy, but that the knee replacement itself, unlike our knee, our human knee, has to be replaced every 10 to 15 years. So a woman who is in her 40s will have multiple knee replacements over the course of her lifetime. For Doris Dano, she has suffered from the pain from this accident, which was not her fault. Ladies and gentlemen, in short, we will prove that it is the defendant driver who is 100% responsible for this accident, and it was the defendant driver who caused the accident, not Doris Dano. At the close of the evidence in this case, I will stand up here and I will ask you to award an amount of money to fully, fairly, and adequately compensate Doris Dano, and to award one other thing which only you can award, and that is 100% justice. Thank you. So you see, what we're trying to do is to work through problems that you have in your cases by perhaps using a unified trial. Before we go, questions for any of the panelists? Yes? Where's the question? Okay. Yes, I'm sorry. Peter.
Yeah, I'd like to know from really all three, maybe all four of you, what were the best arguments that the defendant's attorney made in those four cases?
All right. Harvey, you want to start?
That I had a bond for a client who never was going to amount to anything. He couldn't believe anything we said. And it was an argument that caused the case to get settled.
Bob?
I think the argument I'm most worried about is what duty does the church have to somebody? Do they have any affirmative duty from a legal point of view? Railroad position was basically, what do you want, some crazy maniac lays across the tracks, and we tried to stop and he couldn't stop. That was a very simplistic viewpoint, but that was always the viewpoint.
My case hasn't been tried yet. But I'm sure they'll make very good arguments.
Let us know.
Peter, it's a good question. Just for the record, Peter's question was what were the best arguments made by the defense? In my case, the argument was this, by Walter Beck, who I think is a fine lawyer. He was suggesting what I was telling the jurors was that, in fact, the defendant driver must have been thinking about litigation immediately, and he didn't have time to even consider that. All he was doing was reciting the truth of what had happened. So this was the kind of thing where we still had a fight on that, and he was trying to fight me on the medicals a little bit. Okay. Yes?
Evan, a couple of times during your opening, I heard you use the word procedure instead of surgery or operation. Why do you choose that word?
It's just the one that came to mind. You know, there was nothing about it. I mean, I could have used all three. Unless you think it was a good idea or a bad idea.
No, I just never use that word only because, to me, operation or surgery seems to be a more serious word to use.
I never know what exactly is going to come out of my mouth. Procedure wasn't so bad.
Yes.
In each of your openings, at certain times, it seemed to push the envelope on argument. I know it's designed to do that. But my question is, have you ever been called on that, and what have you done to recover from the objection?
Let me give you a suggestion on this. Harvey had mentioned this. I've lectured with Harvey before, and Harvey has actually said, in no uncertain terms, it's a second opportunity to sum up. Now, I've kind of followed that school of thought myself. What happens if there's an objection? Objection, sustained. Ladies and gentlemen, the proof will show, and you just go right on, right? So what you're doing is, by objecting, very often your adversary highlights the point that you're trying to make. So my suggestion to you is you can always spin off on it and then come back to it anyway. But what I don't want to see is I don't want to see you be drab. In other words, you don't have to minimize the opening and the power and the righteous indignation and fervor that you can actually use just to avoid being objected to during your opening statement. Yes.
I have a question. That getting a unified file in a bifurcated county, it seems like you can try and make that argument in every case. The nature of the injury goes to the liability situation, or is it a very rare scenario?
Okay. To do it, one of the things you're going to see when you take a look at these cases, very often you have to submit a doctor's affidavit along with your motion papers. It's not something that you can just say, hey, judge, we want this because. You're actually going to have to show, sometimes through a biomechanical engineer, sometimes through an orthopedist or a neurologist, as to exactly why it is. I will tell you, it's not the kind of thing that you can do as a matter of course and get it. It's just not going to happen. It really has to have an important bearing on the nature. That is, the nature of the injuries have to have an important bearing, or be inextricably bound, sometimes they say that, with the liability.
If I could just follow up on that, you know what the judges are doing? They're getting very smart. They don't want us to have unified trials, but they don't want to be reversed. So what they do is they allow us to put on limited medical testimony as to the injury without anything about pain and suffering or future damages. So basically, you lose. But the court will not get reversed
Do
on
you
it.
submit that application to the judge you're assigned to in writing, or you can do it
Well,
to sponte?
the problem is you want to do it before you get to the judge, because you want to organize. You want to do it in the trial assignment part. But they don't want to make a decision,
Right.
so they're going to refer it to the trial part.
Yeah, let me just, Harvey's absolutely right. One of the things that you want to do is, you don't want this to be a last-minute thing where you may or you may not get this. Move on papers. Allow yourself the opportunity to actually get a ruling on this. It's a much better way of doing it. It's the right way to do it. That's what we like to do in our office.
Your injury is called a bumper fracture.
We wait for summation for that part. You have your orthopedist say that. Yes.
Evan was the only one who anticipated a defense and attacked it in his opening. Why didn't the other attorneys do the same thing in their openings?
I can answer for them. A lot of judges don't let you specifically spell that out. I've been stopped on that.
You did it in a very subtle way, though. You said, well, why would this doctor do it? And you said, well, here's why, because this was available, he ignored it, this was available, he ignored it.
You didn't listen closely enough. He did say, the defense will say, and that's what he was referring to when he said, I've been stopped on it, where at that point, the defendant will say, Judge, I'll speak for myself. I don't want Mr. Torgan to speak for me.
But you have a fallback position, and you can just say, well, the evidence will show that.
So is
You
it,
just
as a
go
general
back.
rule, is it best not to anticipate that and just let the defense do what he has to
No,
do?
I think you should
Depends on the
always-
case, I can't say that.
you should diffuse everything in jury selection and opening, I think, if you can.
Yeah. Yes.
The dark and stormy night approach, I think it was by both of you guys, and I've read about it, you know, the way you've done it in the law journal. Is that what you usually fall to when you do your opening, to go to the dark?
You need a dark and stormy night.
Yeah, you need a catastrophic injury to do that. Otherwise, it's not going to work. So be careful with that. That's few and far between.
One last question. It's a general question. When I started practicing, the rule was you had your plaintiff there for every minute of the trial, because if they didn't care about the case, the jury wouldn't. Now it seems like just put your defendant, the plaintiff on, and he's done, and then you don't see him again.
Let me just answer this, because I've learned this from Harvey and Bob, who have both told me you don't want to immunize the jury to your client when your client has very severe injuries.
You get them out of there.
No, I know. You get him out of there on the very serious injury?
But you have him there for summation and opening of his testimony.
And a minor injury?
And maybe when the defendant's doctor's testifying that there's no injury to him.
Okay, and if minor injury, you just get him on and get him out.
They're going to be there. Yes.
Yeah, what do you do if you make a motion in limine on, let's say, an issue that you think you're trying to keep out, a damning issue like alcohol consumption in a motor vehicle accident? You know, you play in your odds, you might be able to keep it out, you might not, but the jury says, well, let the trial judge decide. You get in front of the jury, you got a high alcohol reading, obviously you got to shock the alcohol, but I'm worried that if you don't come totally clean, they're going to think you're holding something back.
My way of doing it is you will come clean. As far as I'm concerned, your credibility is more important than any witness that will ever testify. And that's why I would say in a case like that, ladies and gentlemen, there's something you need to know. I want to be the first to tell you, and I want to tell you about it completely. There is no issue that my client had been drinking. There is no issue that my client had been drinking a lot, that the blood alcohol reading was 0.21. It's not something we're proud of. It's something we want you to know, and our position is that is not the cause of
You
the
think
accident.
you might be able to get it out in a motion?
If you win the motion in
He
limine,
doesn't know if it's coming in or out. That's
I'm just
the problem.
saying, if you win on the motion in limine, you don't have to say any of this.
Yeah.
Yeah, it's coming.
Motion limited is after you're.
You have to make it before you open.
Yes, yes, that's what
You
I'm
have
saying.
you have to make it before jury selection. The problem is no judge is gonna wanna rule on it.
That's what I was saying earlier.
So then
Well,
forget
that's
the
your
motion.
problem.
It's the problem, so you might have to hold off until you might have to deal with it in open.
Do it in the trial assignment part, do it in the IAS part, if you think it's a good assignment, do it there. But none of us think about that stuff until it's too late.
Too late.
All right, thank you all.
Thank you.